I suggest we begin our panel, organize a discussion, and ask everyone who has come to share their views. So, we'll be talking today the important topic of law and its role in the formation of different sectors of economy. It's been discussed a lot. In countries with developed economy, law plays a very important part. Can we say the same about the countries with developing economies? One important issue: how does the law and the legal profession develop in conjunction with the developing economies of these countries? And I suggest we discuss these questions, and I give the floor to Hassan Sissé, the Deputy General Legal Consultant of World Bank Group.
A kind introduction. I'm delighted to be here at the St. Petersburg Law Forum for the first time. And I would like first to congratulate the organizers for a wonderfully well put together conference. I would like to apologize before I start because unfortunately I will need to leave before the end of the panel. I've been advised that because I need to catch a flight and there may be, because of the rain and some road closures, I need to leave early, so I very much apologize about that. Now, on the topic of the discussion, the role of law in economic development, I would like to approach it from three perspectives. First, I would like to discuss what is the assertion today or the consensus in the development community about the role of law in economic development. Two, I would like to discuss the state of the debate among economists and other development practitioners as to the role of law in economic development. And finally, I would like to say something about the tools that development practitioners are using in the area of legal reform to spur economic development. So first, the assertion. What is the assertion of economic development agencies and other development practitioners about the role of law in economic development? I will start with my own organization, the World Bank, and what we generally assert is that improving the performance of law and legal institutions is a critical factor in the economic development process, and it helps lift economic performance and the well-being of people. And therefore, the World Bank, like all development agencies and other development professionals, believe that the recipe of all responses to development should include measures to strengthen the functioning of legal systems, improve access to justice, and solidify the rule of law. And what is bolstering that is actually a very strong body of research that shows that economic development is strongly affected by the quality of institutions. As many of you know, the field of institutional economics was developed over the last 15, 20 years, and to a certain extent was a response to the demise of the Washington Consensus as a way of addressing economic problems in the developing world. Another dimension that shows that shows also that this assertion by development practitioners and the global development community is right is that when you look at the global challenges today point to the fact that law and the rule of law in general are important for global economic and social welfare. You look at, for example, the issues of illicit actions in the international sphere. In order to address them, you need to have strong legal and judicial institutions at the international level and also at the national level. You look at the challenge of post-conflict countries such as Afghanistan or Liberia and the like. These countries do need to have the rule of law rebuilt in order to actually better take off in respect of their development. The law also helps address issues that at the international level you hear a lot talked about, which are issues of equity, inclusion, and justice in general. And again, law is an important instrument to make that happen. And finally, for the business environment, both internationally and nationally, everyone knows that if you strengthen the business environment through laws, you are creating better economic opportunities for the people around the world. So this is the consensus, this is the assertion of economic development practitioners in general in respect of the role of law. But that does not hide the fact that there is actually an intense debate going on these issues. Some economists are actually arguing that there is no causality between say strong legal and judicial institutions or rule of law and economic growth, and the debate is going on. But if you ask the question, how do legal systems affect economic development, maybe the most obvious answer is that these institutions, if you have them, they help create a stable economic framework that protects rights, that fosters certainty among economic agents, and the progress in building and strengthening these institutions may be decisive for the success or failure of economic policies. And there is also empirical work that has been done by economists that has concluded that the quality of legal institutions correlates strongly with economic development. But that's where maybe the problem arises. Correlation does not mean causality. And economists are saying, you do not have that direct link that says you have good legal institutions, you are going to have economic development ipso facto. And there are some countries where arguably you can say that maybe rule of law is not there, at least by certain definitions, but they have great economic growth. So the debate is there, and some have argued that actually there might be a correlation in both directions, that you have countries with low economic growth that translate into a weak legal and judicial institutions, and that leads in turn to weaker economic growth. And on the other side, countries that have strong economic growth tend to have good legal institutions that correlates with good continued economic growth. So you have that issue. And really the problem that economic thinking is faced with is how do you break the vicious circle, especially in the case of low economic growth countries. So there is not a clear answer at that level. There is a great deal of research that is going on. Some of you might have seen a recent article in The Economist actually dealing with this very issue. So the debate is still going on, but at a minimum, it looks like a consensus is emerging that good legal institutions, even if they do not affect the quality and the strength of growth in the short term, do have a major influence on economic growth in the long terms. Now, very quickly, let me get to the tools. What are the types of legal reforms that support economic development? And this is, in a sense, a response to the first assertion that I had mentioned, which the development professionals have, that the importance of laws and judicial institutions. The types of legal reforms that support economic development are of three natures. One is about the laws, one is about the institutions, the other one is about legal education. The laws. I think that it is known in the area of legal reform that you do first and foremost need to have good, smart laws that are targeted to the specific needs of a particular country in order for those to actually work. And these laws are supposed to create good incentive systems for economic actors. They have to create stability and predictability, and also be accompanied by a good dispute settlement mechanism. But more importantly, you do not need to just have good laws. They need to be enforced. You need to have a good implementation mechanism. In many countries, you go in, they show you the array of laws that they have. The laws are great, but nothing is implemented. So the challenge of implementation is critical. The second set of tools has to do with institutional reform. Again, you can have good laws if you don't have strong and effective institutions, nothing is going to work. And the effective institutions include the justice institutions in general, in a very broad sense, but also all the accountability mechanism in a society that would make sure that the executive is being looked at by those accountability mechanisms. And finally, I should mention also legal education as a tool, because without the legal education, the institutions will not work, and the laws do not have people who actually have the requisite knowledge to make things happen. And legal education is the one that is targeted to the legal professionals in general, including lawyers, but also to judges and those who work in the judicial sector and in law enforcement. And finally, and also very importantly, to citizens, because the information of citizens, their knowledge of the laws and regulations and institutions allow for greater accountability of the executive branch. So in short, as I mentioned, there is an assertion that law, good laws, rule of law in a global sense helps spur economic development, but the state of knowledge in this area is still something that is an evolving process. However, there is some understanding of or a consensus as to the tools that can be used to foster economic development. And I think that this is what has been discussed so far in this forum. And I hope that these few remarks would have contributed to the debate. Thank you very much.
Thank you for your opinion. Are there any questions? Questions now and your opinions after the panel. Okay, thank you. Yours was a very wide presentation and apparently quite complete, and your opinion was supported by most people in this audience. So now I would like to give floor to Falk Tischendorf, who is the representative of the legal company in Moscow. He has worked in Russia and in Germany, and he can give an overview of some things from the point of view of a foreigner, but a foreigner who has worked for many years in Russia and knows very well all the details and problems from inside. So the question is, how can business influence the law, and how can law influence the development of the business? It is well known that economy is one of the moving forces of the development of laws, and it's mutually adaptable. So we would like to hear your opinion.
Please turn on the microphone. Пожалуйста, включите микрофон. Пожалуйста, включите микрофон докладчику. Дамы и господа, уважаемые коллеги, пожалуйста, говорите в микрофон.
Was asked to come to St. Petersburg. I was asked too if in which language I will speak here, and I decided we are in St. Petersburg, and that's why I would like to talk to you in Russian. Уважаемые дамы и господа.
Dear ladies and gentlemen, dear colleagues, the issue of business influencing the law and how law can secure the interests of the business development is not just a theoretical question. I say it especially because there are different theories on this issue, but it's also a very important issue on understanding how can we influence social, political and legal development of our countries, our regions. And if we look at the Europe and Russia, the development that we currently see in Europe and Russia are closely related to this issue. And speaking at the session of the State Council, Dmitry Medvedev confirmed the necessity of development of Russia by 2020 to become among the first 20 countries with the most comfortable business climate. The most important indicator in the progress toward this way are reports, and I'm very happy to have Hassan next to me, are reports of the World Bank. Currently, Russia occupies 120th place, but in 5 years is planning to get to number 40. It's a great step, it's a great foray which is being planned. In the reports of the World Bank, there is published a rating estimating legal situation in the country. The World Bank, combines economical analysis of the law, and it's a very interesting issue because here we understand how law and economics work together, what kind of relationship between law and economics exists. Despite the fact that I'm personally skeptical sometimes about these reports, there are at least the following question. What does this report and the desired economic reality has to do with the legal area? How the law should act in order to implement this goal, and what is the relationship between economics and law, and first of all, what is their mutual relationship and influence? And it's a very important issue because at the first sight, law and economics are two opposite extremes. Economics based on aspiration of each person aims at the creation of a new type of management of cash flow and flow of goods, which sometimes leads to uncontrolled activity, while the law enforces controls, calls for caution, and sometimes, and that's what lawyers are always quite often told, sometimes it hinders economic activity. On the other hand, economy is one of the vehicles, one of the drivers of the law development. On one hand, the new tendencies of economics, they force a law to adapt. First, there is an idea, then a product, then promotion, products promotion to the market, and finally, application of the regulations on competitiveness and manufacturer responsibility for the product. One of the first laws of Russia became the law on protecting consumers' rights. If we look at Russia, I can compare it with the situation in Germany. If we look at Russia, then we understand that many laws within the last 20 years were adopted because Russia has realized that these laws are necessary for the economics. It was clear that, for example, there is a law that has to regulate collateral real estate. Our law on leasing was a necessity. I remember my first participation in Moscow arbitrage, where we discussed the leasing law in the German rule, where the judge asked me, at me and said that there is no law on leasing in Germany, which exists even here in Russia. So I think it's very important that codified, or as we say, written law in Russia within these 20 years has developed quite well. The problems are with its application. On the other hand, the law defines trends and borders of economic development, securing productivity of many industrial processes taking place in industrial society. Therefore, the law has to adapt in order to justify its existence. The law has to the legislator has to look at at the demands and the needs of economics in order the law to facilitate economical development. Inefficient laws, inefficient application and execution of the laws, especially the latter part, cause economic damage to the state and society, and thus to each of us. Therefore, in the modern state, economic efficiency of the law has to be secured, first of all, in order to deregulate the economy. It's a questionable issue. There are a lot of arguments in them. To abolish bureaucracy, no arguments about that. And in the interests of future generations and the promotion of economic business activity. How the law regulates. Here is one example. Can you imagine what would happen if drivers participating in the traffic will ignore the traffic lights and will go wherever they like? In a small city, in a small town, the consequences would not be as tragic as in St. Petersburg or in Moscow. Each of us knows so-called pressing horns in traffic jams as a reaction to untimely switch of the traffic lights. And in the same way, the collapse of economy and chaotic state of economy is pre-programmed if the law ignores what economics demands from it. Therefore, the main task of the law is to direct economic processes in the right avenues, the right venues. Sometimes such supremacy of law is interpreted as limitations put on economy, but this is in fact optimization of business processes and tendencies of development. And respectively, and I would come back to the opposites which I mentioned, economics and law are two opposites united in unity, and in case they are coordinated, they support each other. Economics forces the law to adapt to reality, while the law does not allow business to let business process to be uncontrolled. Biologists call it symbiosis. And this symbiosis process, ladies and gentlemen and dear colleagues, is an art of life. Thank you. Thank you very much. Mr. Tischendorf, are there any questions? Thank you for a great presentation and as a lesson of a good Russian language and great command of Russian terminology, and I think we can follow the suit and try to make our presentations abroad in the local language, and it's very much appreciated. Thank you. And now a question to you as to a person who has worked for a number of years in Russia. Our Prime Minister, yesterday at the plenary session and many times before that, has said and presented idea of an open government, that we have to create channels through which different groups and individuals and civil society institutions and commercial organizations will be able to effect the approval of certain legislation, to provide expert assessment of the new legislation. On the other hand, he said yesterday that it's also required in order to make new laws not just of a high quality, but to exclude corruption factors through the influence of lobbying groups. I understand there is no short answer to this question, but how can we achieve this balance? On one hand, we allow maximum discussion, getting propositions, and everyone proposing has a goal. On the other hand, we have to leave corruption influence. We have to avoid corruption influencing the process. I believe that it's a good idea in general. I would like to say that as of today, as I see it, and it happens quite often, I have taken part in drafting two laws, and I believe that the most important thing is to define clearly the competence if we are talking about the development of drafting a new law. My position is that we have different ministries arguing of having competence and expertise in the area of this or that draft, different influences, and I have to say about the influence on the consumer protection law, which has been adopted in the beginning of the 90s in the development of New Russia. The idea was to protect the consumer from all kinds of goods imported into the country. But we got the law combined from fragments of laws from different countries, sometimes contradictory. Well, it has been changed through all these years. What I'd like to say that it's a good idea, but we have to clearly define who has competence in which area and how these companies or interest groups may participate, in order to avoid a situation when the law fits the requirements of certain foreign investor, but not the needs and requirements of the Russian Federation. Thank you. I'd like to say that the Minister of Justice, Mr. Konovalov, agrees with you. He said previously we have to adopt a law about the procedure of adoption of the legislation of the Russian Federation, which is being discussed for like 20 years and being developed for all this time. And he many times spoke about the need to adopt such a law, you know, to understand who and how and on what grounds is able to influence this or that legislation. Colleagues, do you have any other questions? No more questions. Thank you. I suggest we discuss another global issue dedicated to harmonization of the legal systems of different countries, globalization of the world economics, facilitate the unification of and harmonization of legal area. And I would like to answer this question the outstanding representative of the law, Valery Abramovich Musin, who is the head or the chair of the law department. He's the corresponding member of the Academy of Sciences and corresponding member of Gazprom Society.
Dear colleagues, first of all, I would like to stress that it's an immense pleasure for me to be able to speak at such an important international forum. Speaking of the development of law globally, I think you could say that this development happens under the sign of two connected but differently oriented tendencies. One of them, Mr. Medvedev, our Prime Minister, talked about that yesterday, and the President of the Arbitration Court, is the competition of different legal systems. They both stressed quite correctly that when such competition doesn't have any elements of pressure and happens naturally, there is nothing bad about it. It's useful because it helps different legal systems take the best things from each other and to mutually enrich itself. On the other hand, as the world economy is being globalized, and this is becoming more and more important, there is also the convergence of previously seemingly opposite systems. Just one example. It has been traditionally thought that the continental European system acknowledges only the written law as the source of legality, while in the Anglo-Saxon system there is also the precedent law. I think that now you can't really say that in our country, which has traditionally belonged to the continental European family, mostly to the German version of it, precedent does not play any role as the source of law. First of all, the Constitutional Court is based on precedent system, and not just that, also the precedents of the European Court for the Human Rights also are binding for us. Also, the High Arbitration Court has officially stated that at least some decisions, not just the plenum but also the presidium, could be construed as precedents. So it's obvious that there is some kind of convergence of two seemingly opposite legal systems in a very peculiar issue as the source of law. And this leads us to another trend which is also becoming more and more relevant. This is the trend for international unification of material, first of all, but also processual norms. One of the examples is the convention which is pivotal for the international trade, the Vienna Convention on purchasing and sales. Most countries of the world joined it. And what is the source of its success? It is a compromise, taking the most viable elements from continental and the Anglo-American system. Apart from that, 99.9% of it consists of dispositive norms, and it helps participate in this convention to the countries that have different legal systems. This convention is a great example of international unification of material legal norms, which of course help develop international trade. We all know that trade precedes politics. Well, trade is economy, and that's why economy necessarily precedes law. But law has to feel the development of the economy's development and create such legal instruments, such legal tools that would help further development of the economy, including unification. Also, a law cannot be apart from economy, but it can also not be apart from technical progress. Look at the telecommunication market. Quite recently, there was a convention on electronic trade, which officially says that electronic drafting of a contract is equal to its signing manually, and it makes international communication much easier. But I would also like to stress that the new telecommunication means help us speed up the drafting of contracts, drafting of transactions, but also the deliberation of arguments between the participants and speeding up many procedures. Today, if a law of a foreign country is applied as the material law, usually an expert from abroad is invited. So they have to come to a different country to make a speech and so on and so forth. But I think that today the development of telecommunications makes it possible to do it all using telecommunication means. I'm quite convinced that in the very near future, in this area, there will be a mass-scale unification, and as a result, the arguments which are an inevitable part of international trade will be sped up thanks to this technical progress. So the most important thing is that these seemingly opposite or mutually exclusive tendencies, the competition of legal rights and their convergence and international unification, they would make it possible for the law to be an optimal tool for the development of economy. By the way, such means when law helped the development of economy have existed since antiquity. The Praetorian Right in ancient Rome allowed certain exclusions and then generalize it and create such legal norms that would help develop the economy. There are no Pradas now, but there are telecommunications, there are connections between different legal systems, there is unification of both material and procedural norms internationally, globally, and thanks to that, law necessarily lags behind the economy, but being a reasonable compromise which is embodied in conventions. It is helping now the development of international and national law in different countries. Thank you very much. Thank you. Thank you. Any questions? Yes, please. Please speak into the mic. Stanislav Lazovsky, St. Petersburg. You said about the precedents that are used in the work of the Constitutional and Arbitration Court, but you didn't mention the Supreme Court. Do you think would it use the precedents, and if not, why? I think that we always have precedents as a source of law. I'll just cite one case before the war, before the Second World War, the case of Martinique. The essence is this. An engineer, Martinique, went on holiday on a train. A train was at a small station. Martinique is on his bed, but he sees a fire of an oil car on the next track. He goes out and he's injured while trying to extinguish the fire. So this case went all the way to the Supreme Court. So there is no delictum. There is the railways did not anything wrong. Finally, using the analogy, the Supreme Court said that our legal system doesn't allow for this situation to happen, and so the payment was made. But then, in the codification of the 1960s, based on this and another precedent, they were laws on the salvation of socialist property. So basically any action in the interest of a third party without any direct order. So it happens unofficially, and I think that the Supreme Court will be within the framework of this tendency. Thank you very much. Any other questions? Yes, please. Alexei Makarov, the Legal Assembly of St. Petersburg, but I'm your former student, so this is my question here. A student cannot be a former student. So my question is, we see a very evident tendency for the competition of different legal systems. Some issues are taken out of Russian jurisdiction. What measures are taken in other jurisdictions for the protection of keeping the companies within their jurisdiction? So maybe this is a question for Mr. Tischendorf as well. Mr. Tischendorf, for the future, when we'll participate in the general discussion. Well, should I answer? Okay. Well, you see, I think that first of all, the attempt to take an argument outside of our jurisdiction are largely based on our and our foreign colleagues' perception of poor perception of the contents of our law. I don't want to abuse your attention, but Sherlock Holmes helps me a lot, one of my favorite fictional characters. Talking to Watson, he said once, "You know, Watson, the English law, in spite of all the formalities that it's burdened with, is very flexible and just. Trust me, I know what I'm saying. The Russian law can be very flexible and just if used correctly, because right now our civil code, especially in the version that is going to be adopted, it's very market oriented, and if you apply the norms correctly, you don't have to go anywhere outside the Russian jurisdiction. So our jurisdiction is quite adequate for the protection of both our and foreign investors." Mr. Dadov, who is my next door neighbor, will correct me if I'm wrong, but to the best of my knowledge, 70 to 80% of the arguments are decided in favor of the taxpayer and not the tax inspections. So you don't have to be afraid to apply to Russian courts that can actually efficiently protect the investors' interests. Thank you very much. Are there any other questions? Okay. Well, okay, another question for you. I'm in charge of the chair of the law of Russian Legal University. How do you think, what do you think about the possibility of reviewing certain cases pursuant to the publication of the new legal documents which allow for a different view on the law? It is connected, and the reason for that is very simple. You quoted the relevant law, but you didn't quote it in full, because the review is possible regarding new and old evidence, and this is the answer to your question. Yeah, I wanted to answer to this very interesting question, because here economy is influencing the law, and we see it. I wanted to say that there are two issues here. First, foreign investors do not trust the Russian law, or they don't know it. I know many transactions that were concluded according to Swiss law or in any other jurisdictions, which are not relevant to the parties at all. If we speak about purchases, sales, construction, here there are no reasons not to conclude these transactions under Russian law. Another sensitive issue is the creation of joint ventures, where it's necessary to say that there are certain issues at stake in Russian legislation, Russian law, where you have to take into account, where you have to look more attentively why such contracts are being concluded, why such joint ventures are being contracted under Dutch law, and so on. And legal issues are at play here.
Thank you very much. Here is a provocative question. As the head of a large law firm, do you recommend Russian jurisdiction to your customers or Western? Well, we recommend to make a contract on the Russian law if the Russian law is in favor of our customer, of our client. In many cases, it is true. If we're talking about creation of a certain business in Russia, for example, we are creating joint ventures in Russia and also in Germany, and then it works through subsidiary in Russia, but it depends on a specific case. But one may not say, and I agree with what has been said, or let's conversely, sometimes an other law is applied because there is no trust for the Russian law, because they don't know Russian law. And then we have to explain to our customers what the Russian law provides. They're surprised. For example, Russian legislation has laws which are in favor of investors, unlike Swiss, German, or other. Thank you. It was very nice to hear from you when you said in our Russian law. It speaks a lot. And here we may continue the discussion. It's not a secret that foreign investment in any country are one of the most important factors of the development of the economics of this state. However, a lot has been discussed about fears that contract terms on which this investment is attracted into the country's economy, they place many limitations on the country itself. And these limitations prevent achievement of social goals which are at the first sight unrelated to the development of the economics itself. And I'd like ask Mr. Spears Mrs. Spears to tell about it. She's the lawyer of international law firm.
I'm sorry, but thank you to the marvelous interpreters that we have here. It's an honor to participate on this panel. I was initially going to talk about corporate social responsibility, which is something I'm very happy to talk about later in the question and answer period, but the chairman presented us with some discussion questions that were very interesting, and then also following upon the Prime Minister's discussion of sovereignty concerns yesterday, I thought that actually talking about the work that I do, which is an international investment arbitration, would be perhaps a more appropriate subject to begin with, and we can talk about some other things later. I wanted to talk to you about a problem right now that is being perceived. Whether it's actually accurate or not is yet to be determined, and that, I think, comes back to some of the problems our World Bank colleague was discussing in terms of the lack of empirical evidence often to support what role the law plays in economic development, and I would offer the a request that the World Bank help us try and establish some of this empirical evidence. But the perceived problem at the moment, and I'll discuss the problem and then I'll discuss some of the solutions. The perceived problem is that international investment law is inhibiting host states in terms of policy options in non-strictly economic areas, such as in social regulation and environmental regulation. Now, that's the problem. I'll also discuss why attention has focused on this problem right now, and then finally I'll discuss some of the ways in which states are addressing this problem in their treaty practice. As a preliminary matter, I should just explain, by international investment law, I mean engagement in this vast network of international investment agreements. There's some 3,000 now. And there are about another 300 free trade agreements that have investment chapters within them. Russia is party to some of these bilateral investment treaties, not with the United States, although I'll point out that just a couple of weeks ago I understand that Russia has called for talks with the United States on a bilateral investment treaty. And the U.S. is about to resume talks with China, and that would be sort of the mother of all bilateral investment treaties. I think if the U.S. and China were able to establish one, a lot of these sovereignty issues will certainly come to the fore, and I predict that in the next few years we'll see a lot of talk of some of these issues. I should note that bilateral investment treaties really were a product of the Washington Consensus, which also our colleague from the World Bank was discussing earlier. They were part of a package of reforms that was promoted by the bank and the other international financial institutions in the 1980s and 1990s, and the vast majority of these treaties were agreed in the 1990s. They drew on neoliberal economic ideas, which call for a very small role for the state. Essentially, the state should protect property rights and contract stability, and otherwise we should scale back the role for the state in the economy. it was thought that the participation in the international investment law regime would attract foreign investment, and that also, in turn, foreign investment would attract economic growth. And these treaties were supposed to be accompanied by rule of law reform, which, as I mentioned, during the 1990s Washington Consensus perspective of that, meant essentially contract enforcement and property right protection. So to turn to the problem, namely that an international investment law has come to be perceived as unbalanced. It's perceived as unbalanced in favor of foreign investors and against host states' need to regulate in favor of other non-investment policy objectives. There are various strands of this argument. I won't go through them all. One commentator has gone so far as to call the law of international investment the law of greed, because it says it is designed and enforced in order to support the interests of multinational corporations. I would love to discuss that further, but won't have time right now. The issue I'll focus on, again, is this need for policy space. And again, as I've said, the concern is that certain policy regulations that states put into practice, particularly in social and economic areas, could be held to violate these treaties because, for example, they would constitute an indirect expropriation. And in fact, treaty tribunals have held that sometimes regulations can constitute indirect expropriation. Or, for example, they would be held to be unfair or inequitable, which is another provision under many of these treaties, or that they are somehow discriminatory against the foreign investor. So the concern is that these treaty awards, which are quite large often, especially in a developing country, an international arbitration award against a state can have very significant impact on the budget of a country. The fear is that in order to avoid these awards, countries will not pass necessary regulation, and thereby creating what's called a regulatory chill effect. This concern about regulatory chill arises from a number of cases that have been brought, particularly against Argentina. Argentina was subject to a massive financial crisis at the beginning of the century, and that has spawned a large number of lawsuits against Argentina for economic regulation that they passed. Similarly, the United States has now finally felt that these treaties can actually come back to bite their drafters because it's been subject to lawsuits in the United States under NAFTA. The other real concern is some of the case law and investment law treaties has been quite contradictory. It's also been expanded. The jurisdictional aspects as well as the substantive requirements have been expanded quite far in favor of investors in some cases. And that is because the nature of these standards is actually quite indeterminate and quite broadly drafted, and therefore arbitrators are able to fill in the gaps and expand them quite far. Now, why is attention turning right now to this concern about the lack of balance in the investment law regime? I would posit that there are three primary reasons. First, in the 20th century, as we've heard, we've seen the demise of the Washington Consensus. Basically, the Washington Consensus didn't bring the expected results, nor did these investment treaties necessarily. There's a lot of questions about empirically whether investment treaties are, in fact, bringing the expected foreign direct investment. So there are a number of countries now taking another look at the neoliberal vision, as are the international financial institutions. I would say, and our World Bank colleague will do a much better job of explaining the new development paradigms that have emerged. One might be called the new developmentalism. This is essentially trying to reach a compromise between the market and the state and ensuring that the state still has the potential to regulate the market where necessary. These are sort of chastened liberals. They still believe that the market is important, but yet believe there's a role for the state. And then on another extreme, we have what I'd call the 21st century socialists. These we see in Latin America increasingly, Venezuela, Bolivia, Ecuador. These were the first areas to get very heavily involved in investment arbitration, and now they are withdrawing from the system. As a second change from in the 21st century, the reason we see this issue of balance coming up in investment treaties, it would be because we have a new definition of development. Development is no longer measured exclusively by growth and GDP. It's also now being measured by social and economic indicators, indicators of well-being. You see this in the Human Development Report by the UNDP and also in some of the World Bank publications. Third, we have the development shift, or the shift in the development paradigm has also caused a shift in what we mean by the rule of law. Again, rule of law historically during the Washington Consensus was very focused on contract stability. We are now also talking about institution building and a much broader menu of development options. And fourth, I think I said I had three, I have four. The fourth would be that there's a massive shift going on in the geopolitics of international investment law. Historically, investment law was a north-south phenomenon. Capital tended to flow from the north to the south. That has changed dramatically in the last 10 to 20 years. We have now capital flows going north to north, south to south, even south to north. As I said, these mother of all investment treaties coming along, if we're going to have China and the US and Russia all having investment treaties, these are no longer flows of capital going one direction. These are going to be flows of capital going both directions. And I think the parties to these treaties are suddenly going to be a lot more sensitive to sovereignty issues when they realize that they are going to be subject to investment arbitrations, just as historically developing country recipients were of capital. Now, finally, how are states responding to the need to rebalance the international investment law system? They're doing so in about 5 main ways. First, some countries are asserting new defenses. That would be Argentina. Argentina is also trying to get annulled some of these arbitral awards. It's been subject to more arbitral awards by far than any other country. These come out of its financial crisis at the turn of the century. Second, the 21st century socialists, again, Bolivia, Ecuador, and Venezuela, they are withdrawing from the system of international investment law, or seeking to do so. They're currently subject to a lot of these cases, but they're trying to withdraw from the regime. Third, a number of countries have issued joint interpretations of their treaties. So, for example, the NAFTA parties have tried to say this is what we actually meant when we agreed these certain standards, and in that way somewhat narrow the scope of the standards. Fourth, one country, which is Australia, has decided to withdraw altogether from the investor-state dispute resolution process. Australia has its reasons, namely I think it feels that its judicial system is sufficient for foreign investors investing in Australia. What it intends for its investors overseas, I don't know. It's basically leaving those investors to try their luck in the judicial systems where they invest. And fifth, we have a number of what I would call a new generation of international investment treaties. Now, these investment treaties attempt to rebalance the what has been considered the unbalanced nature of the treaties in favor of investors. They've sought to rebalance them. They've done so in a number of ways that I won't go into extreme detail about, but essentially they've put interpretive statements on the substantive standards that seek to kind of roll back the standards somewhat. The U.S. Model bilateral investment treaty is actually a key example of this new generation. It's interesting, it was adopted during the 2004 one, adopted during the Bush administration. I would venture to say I don't think it was concerns about sustainable development or about development overseas that motivated the U.S. government to make these changes. If it had been made under the Obama administration, those might have been the concerns, but under the Bush administration, it was concerns about sovereignty. It was concerns about the U.S. being able to regulate when foreign investors come in. It might also be anticipating things like state-owned enterprises and China's foreign sovereign wealth funds investing in the U.S. You want to be able to make sure you can regulate those. So the U.S. has put a number of qualifications on their substantive standards which allow a lot more policy space for regulation. Second, some treaties, such as the Canadian Treaty, provides from some exceptions altogether to the standards. If you are regulating in the interest of health, human safety, a list of things, you're effectively exempt from the treaty's requirements. Finally, some countries have put in the preambles of these treaties other policy objectives. They have put them on the same normative plane as economic policy objectives. So historically, these treaties said the purpose of this treaty is to provide and promote and protect foreign investors. They now say, and also to promote sustainable development and a litany of other things. And the reason preambles are important is under international law, you interpret a treaty in keeping with its object and purpose, and therefore you look to the preamble. Finally, the U.S. and other countries have put environmental and labor chapters in their investment agreements, meaning they essentially are saying host countries shall not lower their regulations in order to attract investment. And that's been very controversial in some ways because businesses say it'll make it very hard to conclude any of these treaties because we're essentially putting requirements on the host state. But it remains to be seen how those will work out in practice. So in conclusion, I'm sorry I've rushed through because I know I only didn't have long. The main challenge right now facing bilateral investment treaties, I believe, and as we go forward into this new age of negotiating these treaties, is going to be how to ensure that states have regulatory space, both to be able to protect investors, but to also ensure that their sovereignty is protected and that they're able to exercise their police powers to regulate foreign investors. Thank you.
Thank you. Any questions, colleagues? Maybe some of the speakers have questions. Yes, please. Well, there was an example connected with on Sakhalin-2, there was a case of the shared production agreement, and this case was connected to certain political risks. But I see from your speech that such aspects of sustainable development as the environment protection have played a major part, maybe also politically, but the environmental factor was important in this case. Am I correct to assume that in spite of the need, or maybe sometimes we need to curtail the sovereignty of a state in favor of environment and sustainable development? So do these environmental factors play a major role in evaluation of the various agreements and solving arguments? We have to say goodbye to Mr. Hassan Sissé now. Thank you very much for your participation. I'm sorry.
Last piece of the question, I'm sorry, because I wasn't quite catching up with the transcript. Just the last, do you remember the last two sentences of the question?
What is the role of environmental factors in solving the disputes and various investment issues?
Well, thank you. Yeah, I think, to answer your question, I mean, this is the crux of the problem, really, is that is that there have been cases where an environmental regulation was actually found to be inconsistent with a treaty. And this has been, has caused outrage because obviously then that sends a signal that you shouldn't pass your environmental regulation. So this is a response to exactly those sorts of dilemmas. And I think that in the future, if arbitrators are instructed that they should balance these interests. I mean, there's clearly, you're giving up sovereignty in the sense of you are signing up to this treaty, saying we do hereby agree we are going to be subject to an international minimum standard of treatment. And that's fine. States give up sovereignty all the time when they enter into international agreements. But they enter into international agreements both in the investment field and sometimes in the environmental field. And we're seeing now sometimes conflicts between those two bodies of international law. I mean, that's a whole other aspect of this subject, which is that academics in particular, but jurists are very concerned about the fragmentation of international law, or the conflicts between various bodies of international law. Because, for example, if you have Russia trying to implement environmental obligations that are international or domestic, but at the same time is being told by an investment tribunal that it's discriminatory and it has a negative economic impact on an investor, you've got a country that's between a rock and a hard place, as we say. And unfortunately, we've actually seen a couple examples. They haven't yet gone fully to hearings and on the merits, but Peru right now is actually subject to one of these real dilemmas. Peru was attempting to prevent a corporation from it was trying to actually compel a corporation to clean up this environmental mess that this mine had made. And the company kept asking for more time and more time, and finally Peru said, no, you must do it. And the company has now sued them under a bilateral investment treaty, because as a result of this, the company went bankrupt because the investors pulled out. And anyway, they've had an economic impact. But so they're suing Peru under a bilateral investment treaty. And poor Peru is now also being hauled before the Inter-American Court of Human Rights by the population that was affected by that mine for having dilly-dallied around and not having taken action quickly enough. So you've got Peru may end up having to compensate its own locals and compensate the foreign company at the same time. So that is not an ideal situation. Now, I'm not going to say that Peru necessarily did the right thing, but this is the dilemma that we're facing.
Спасибо. Есть еще вопросы, да? Прошу.
Any more questions, please? Thank you very much. Moscow, it's Federal Drug Control Organization. In the United States, there is a practice of publishing a list of drug lords. And their investment projects are being frozen. Their participation in business activity is also stopped. Is there the practice of International Investment Tribunal, does it consider something like that, the stopping of the drug lords' investment and business activity?
Fascinating question. Not yet, but what is happening is you do see investment tribunals starting to take into account the behavior of the investor. This is a new thing because you understand these treaties only impose obligations on states and grant investors rights. So you don't have, it's not a two-way street, it's a one-way street. However, there have now been some recent decisions where tribunals have found that the behavior of the investor is either a jurisdictional issue or a merits issue in terms of whether they deserve protection under the treaty. Now, these haven't yet gone to, it'd be fascinating to see if there was a case on your investment is in drug running. I mean, that, your investment is in a marijuana plantation. I would assume that the illegality under host government law of your activity would be sufficient to eliminate your claim, probably on jurisdictional grounds, because most of these treaties say you have to invest in accordance with local law. But in terms of whether a drug runner would be subject or to have rights under these treaties, I think in the end tribunals would probably manage to say no. I mean, you wouldn't be able to protect your investment if you're a drug runner. But the question does arise as well, should, and some people have proposed that these treaties should also impose obligations on investors. And that would come back to our corporate social responsibility topic that we'll get to eventually, is whether these should, whether it should be a two-way street. If you're going to impose obligations on host states to do with investors, you should probably also make sure the investors are performing to an international minimum standard of behavior as well. So.
Спасибо, господин Спирс. Еще.
Thank you. There is another question here. Меня зовут...
You talked about the international investment agreements as a network of bilateral agreements, and I just wondered whether there is or should be an international standard of some sort to help these poor Perus to have a somewhat stronger position. Yeah. Thank you.
Yeah. No, it's there's an interesting history of how bilateral investment treaties came to be bilateral. I mean, there so far hasn't been an international consensus that has raised to try and draft one unified treaty. So although we have the World Trade Organization having a unified trade regime, the bilateral investment treaty regime is a chaos. I have a wonderful slide when I do this presentation for even longer. It's called the spaghetti bowl of bits, and it looks like a bowl of spaghetti. You've got, you know, the globe and these treaties going all over the place, and it is a mess, and that's why we end up with some contradictory decisions. There's no formal system of precedent in this area, so you get decisions that go every which way. And yeah, it would be wonderful to see a unified treaty established. The OECD attempted to negotiate one that was called the Multilateral Agreement on Investment. It went down in flames, taken down by the movement against globalization, really. I mean, it was caught up in that whole anti-neoliberal social movement, really. So I think governments in the end decided it was better. It's much easier to negotiate one-on-one. Unfortunately, it also means there's a power differential often when you negotiate one-on-one, so that you can get concessions if you're a big capital exporting country and you're faced with one small developing capital importing country. The two of you are a lot more likely to reach agreement than reaching an agreement on a multilateral level. But if you start thinking about treaties between, as I've said, the U.S. and China, the U.S. and Russia, etc., that will cover so much of the world's capital. I mean, a significant portion. Maybe, you know, the next stage later would be, let's unify all of this and have one standard. But that remains to be seen.
Thank you very much. I think we'll continue this discussion after the panel. And now I would like to switch to a different topic. We know that investments, both internal and external, portfolio and direct, are very important for Russia and many other countries. And one problem that is important is the problem of administrative barriers, which is often almost unsurmountable, which is really a hurdle for economic growth and the development of economy and so on. And I would like Mr. Dmitry Dedov, the judge of the High Arbitration Court of the Russian Federation. I presented a presentation. It's in Russian. Using this opportunity, I would like to thank the organizers for such a wonderful international panel of experts who came to participate in this forum. It's very important. This presentation is in Russian, and so I would like to ask the foreign expert, I apologize, but I hope that things that I'm going to say will be even more interesting than the things I wrote. We'll be talking about legal technologies, and this is an example of forgetting certain things. When legislators forget certain participants, certain subjects of relations. And one example is when it happens, we're all human, it happens. For example, when the tools of regulation of corporate arguments are regulated, there was a very interesting project in Russia where there were certain group claims, and this is some kind of a modernization of legislation. Unfortunately, implementing certain new norms in different laws for different legal persons, certain norms were forgotten to be implemented in the laws on cooperatives, which is very similar to the German structures. And it was just forgotten. The legislator forgot, which led to a certain legal argument, which made the upper level courts to use analogous legislation, which was not completely correct.
the legislator did it on whether the legislator did it on purpose or just omitted some investors. Well, here we'll try if it works or not. Yes, it does. These are the barriers where liberalization and abolition of administrative barriers is taking place. For example, licensing. You know, there is a law that certain activities have to be licensed. At the adoption of this law, there was about 400 types of activity to be licensed. Well, we have a great minister, Mr. German Gref, Minister of Economic Development, who, within the number of years, decreased the number of licensed areas, and now there is less than 100. Those necessary, those activities which really have to be licensed. There is a very good rule in the law that, in this law, that the license has to be obtained, and licensing is used as an institution when other instruments of limitation of freedom of economic activity are possible, which are less rigid and less burdening than licensing. So German Gref's department has offered a number of tools like liability insurance to avoid licensing, or quality increase of production procedure, production service procedure, accountability and registration. For example, real estate rights registration. If one of the participants of the deal, for example, on collateral real estate or mortgage, has died, if it's a physical person, it's a private person, or if a company that provided collateral has been liquidated, has been cancelled. So by the law, both sides of the treaty have to sign an agreement, but for the absence of the other side, only one side signs it, and the registrator declined on formal grounds. He said we need two sides to sign. And it required interference not of the court, because the court has adopted this same point of view for some reason, but the legislator had to get involved in order to make a special rule in the law that in case of perish of one side, the one signature of the other side is enough. It's a milestone that showed that how in Russia the rule of law is implemented, how courts are free. So when it comes to administrative barriers, courts are not independent and not quite free whether to state their opinion of the necessity of such a barrier at all. An opposite example, registration of companies. When it says to increase the charter capital of the company to a substantial amount, like 25,000 euro. Sometimes it's interpreted as an administrative barrier, but in the current situation, it's reasonable. If the people want to create a company, they need investment. Currently, minimum charter capital is 10,000 rubles. You cannot even buy equipment for your activity for this money. A good businessman needs nothing but his ideas, but still they have to be somehow implemented practically. Well, a removal of administrative barriers. The only positive slide that I have here, in a positive mood. And the goals of elimination of such barriers are more liberal market entry, decrease costs, more freedom for business, and eliminate grounds for corruption. Even if we take one of these factors, Someone might say it's not necessarily directly related to economic growth, but in fact, and as a whole, it does have maybe an indirect effect. It does mean that more money the businessman will have. He'll invest in the future in the development. Those investors who have already bought Bentley, boat, and other luxury items. This is the most interesting slide, and it is related to the key issue that I would like to answer in my presentation. The question is, the government, the state, which demonstrates that it is removing administrative barriers or unnecessary limitations, they show that this government takes care of business, takes care of its citizens, about their prosperity. So my question to such a government is, why did you have to create these barriers in the first place? What did you think about when you have established all these bans and limitations, if you now come to a conclusion that you have to remove them, that they are not needed? This is quite a difficult question for any government, and there are a number of reasons, and I will give the reasons further, but from the point of view of legal technologies, I would like to suggest that the things are well known, but unfortunately they are not well taught, and they do not have, there is no system in them. There are principle of proportionality, very well known in academic circles of the world, not only European principle. It was probably invented in Germany, but it's widely applied by European law of justice, by European Court of Justice, sorry. It's a multifaceted principle. One of the criteria is that when establishing certain rules, legislator has to determine, to clearly define the purpose. It's one big problem to define the goal, because sometimes goals are substituted for the means, and then the means are determined to achieve the goal. This is another complicated task, because each person is afraid, and it's part of mentality, of individual's mentality. He tries to be overcautious. Let me put more limitations just in case, because this demand of efficiency of the law, when with minimum limitations legislator has to achieve certain goals. And definitely the definition, as it has been justly said, that the law is a limitation of certain interests. Therefore, we have to understand what are for the goals we want to achieve. We have to understand the interests we want to satisfy. It might be public interest, prevailing interests, the interests which have to be protected. And in this regard, I'd like to argue with the established view which has been presented by our Prime Minister yesterday, that any law is a balance of interest. What about the balance of interests? And also he said that the law is a compromise which we achieve. What Susan have talked about today, when we achieve a compromise, it might be achieved in making of a deal. These bilateral treaties are the examples of such a deals, and investors for each company, and many of the present here know, the main thing is to go for the deal, is to go through, to sign a deal, and sacrifices and concessions are needed, but the deal has to go through. As for the law, situation is just the opposite. although here we also are talking about public interest from the point of view of sustainable development. The balance of interests, I don't like this term, although it's used by the courts. We don't need balance of interests. We need definition of which interests are more important, which are more prevailing. An example of such balance of interests is a law on protection of competition. Quite a solid law adopted recently in mid-2000, mid of this decade. It's modeled after European samples with the participation of international experts. And you've probably heard at the round table, the round tables, we talk about the third anti-monopoly package. Now we're talking about the fourth package. It's massive amendments made in this law. Can you imagine the year 2006? So in 4 or 5 years, it's the third package of amendments to this law. More and more compromises we see in this law. Here is an example, not of antitrust, anti-monopoly law, but a related code of administrative liability, where for the first time, due to the introduction of the law on competition, the so-called reverse revolving fine is introduced when a company is abusing its leading role, then the fine is percentage from the total revenues. So the fine, punitive fine is related to the revenue. So what did we see? Even in those cases when it was a petty violation, yes, abuse of leading position, but not influencing free competition, non-related to relations of a leader with other market participants, but let's say with the consumers. For example, electric company, for whatever reason, doesn't want to connect a user to the network, so he turns to administration, and administration is punishing the company for a petty violation of non-connection, or when the company says, please install the meter, but company has large revenues, and the punitive fine is about $1 million for a rejection of connection of a meter, to connect a meter. So in the third anti-monopoly package, there was a rule that this fine is only valid in case related to the fact when it influences the competition, when it has direct influence on the competition. I'm not talking about natural resources monopolies, who also make violations, but doesn't apply to that area since there is no competition there. Although you understand that the fine is unproportionate. And now about the limitations we may have, that we might have been avoided initially. A lack of public discussion of the draft, or in case there is public discussion of the draft, but proposals and suggestions from the market participants are ignored. They submit their suggestion, then a series of quite unclear consultations start, and it results in a compromise. No relationship between the between the regulator, and market participants. And the third is the reasons are
So when the authorities are not thinking about the interests, when they are just enjoying their power, the problem can arise due to a low level of confidence and of unintended use of legal institutions. I would like to explain it from the point of view of legal technology. The legislators are putting up barriers pursuant to certain cases of abuse or infringements which were committed by other participants. So then certain persons who are either working in good faith or not are suffering because they're under the influence of limitations imposed on people who are not acting in good faith. I think that these limitations, these barriers, are not right, because if some institution was abused, for example, the certain institutions of civil law, which are quite complex, and civil law specialists don't consider them to be administrative barriers, even though they are actually barriers. These are the institutions that are supposed to make the civil rules simpler, but in many cases such institutions are abused by certain participants. These institutions are very old, they have a long history, but even though they are not adapted for real abuse, well, there are different examples in history, there are new generations and so on, but there are examples that show that the courts are managing specific instances of abuse. And last, I would like to end on an interesting anecdote. The difficulty of finding out the prevailing interests. How can you disentangle these interests? Then you find a group of persons whose interests are really protected. Imagine a new house which is in a lane where the traffic is one way. I think traffic regulations is a very good model of certain limitations and their reasonables. And this limitation is very unreasonable. It's in Moscow. It's a boulevard, and for example, you cannot make a turn to get to your house. You have to make a really big loop through many 100 meters of traffic to get to your house. So there is a house, there are many people living there, and suddenly the police invalidates this barrier. So it just takes away the traffic sign, and they say that now you can go both ways. And this is very good for the people who live in this house. This is a shortcut to their house now. They don't have to go around. So nobody knows about that. And accidents happen, because you go to this lane, and people who go the other way, they show you that you have violated the traffic regulations because they don't know that the sign had been revoked. So this principle is applied here too, because there has to be a certain transitory period for people to get used to it. Then you find out that there is a high police official living in this house, so he just moved in, right? One-way traffic was there for many years, and then it was suddenly revoked right at the time when this guy moved in. Were these two things connected? We don't know. But at this moment, this limitation was revoked. So where happen many people go there, but you don't have to forget that there are certain people who are really using this liberalization and revoking of these barriers. Thank you. Thank you. You were so invested in this example. It seems like it was from your life. Dear friends, we're a little bit behind our schedule, so let me abuse my rights and just give the floor to our next speaker, and then we hope that we'll have more time to discuss everything that was discussed after the panel. So now we're switching to the topic of the social responsibility of the business, which is much discussed in all countries, not just here, on the level of the heads of states, and such programs are economically costly, but their monetary value is well above the purely financial interests, and it corresponds to the really global interest of the state. So the question is, the social responsibility of the business, doesn't it distract the business from their direct responsibility, from earning money? And so, Anne Bodley from Sawyer Williams would like to say a few words about that. I have to say that my practice, I'm not very practiced in Russian, so I'll have to speak English.
I am sticking to the topic of corporate social responsibility, which was the list of questions that we were, I understood we were to address. And under the rubric of economic development, it's an interesting match. I think the topic would have fit very well with the panel that I attended earlier this morning, which which was compliance and touched on business ethics, because this is almost the next step from that. But it's because it's corporate social responsibility, it fits very well with the businesses that we're discussing, how they transact, and the legal and ethical issues that they face in Russia and globally with their businesses. So at heart, what corporate social responsibility is a step beyond the law. It's in and of itself, it is as structured, it is a self-regulatory mechanism, and it's the idea that corporations have responsibilities to their communities, and their communities can be quite large with global organizations, but that it's looking to ethical, philanthropic, other mechanisms like that as a core part, as a part of how they're structuring their business. And it can have, it is something that's been of increasing importance, I think, in the world, certainly in Western countries, with corporations taking on, going through an evolution, if you like, from from how businesses started up through to a lot of the social movements in the 60s, and adding to saying that with a lot of stakeholders, with parties in the world saying that corporations have a responsibility beyond just their bottom line, and asking them to take affirmative steps in looking to programs that look to, it's a whole wide range of things, however, that fall under this. One of the things that comes to the top of the list often is environmental responsibility. You still have pockets in the world where you've got social programs, more of the sort of the Dickensian nature. Fortunately, in the Western countries, most of those sort of abuses that came out under Dickensian novels have gone away. But obviously in Africa and places like that, they still exist. I think most people would advocate for corporate social responsibility at some level, bearing in mind that it can be a very large topic. But nobody would advocate the reverse of that, saying that corporations should absolutely turn a blind eye to the effects that they're having. And there can be advantages to corporations as well to keeping this in mind. Certainly when the communities that businesses start operate in, it isn't just a one-way street where you take profits from a community, but it is in the corporation's best interest to also invest into that community so that community can continue to support the corporation, if you like. So there are reasons like that. Oftentimes, corporate social responsibility topics come up as well when there's a major disaster, when there's something that happens that causes, for example, environmental degradation, and then people say that then outsiders come in, the community in a whole will come in and say that corporations need to take need to pay better attention to these issues that affect all of us, that are again beyond sort of the business line, the bottom line of that business. So legally, it's well, there are a number of questions that were given to us as to how this might look, and whether, for example, whether or not corporate social responsibility principles should be harmonized. There are a number of ways that could, there are allowances within that for many different cultures. The reasonable minds will differ as to what are the most important things that you would want to look at a list, but there are initiatives through the United Nations, through other international organizations, through the EU and supranational organizations like that, and smaller NGOs that are working towards common, lists of principles that they're advocating for corporations to sign up to, and many corporations do. Some of the numbers are very high in terms of corporations in the West that have corporate social responsibility as an integral part of their investment in business models these days, including that in the analysis. And I might just end it there. Suzanne raised she gave a number of examples that were very helpful, but also given that we are running a little bit behind time, I might just stop.
Спасибо большое, госпожа Бодли.
Thank you very much, Mrs. Bodley. Our final speech today is by Artem Avedisyan, who is the representative of the Agency of Strategic Initiatives, which was created on the initiative of President Putin. And this agency helps the development of business initiatives, helping small business projects reach a new level, analyzing them, presenting them to the government. And this agency plays a very, very important role. They are excellent specialists, very high-level specialists. And the question that he is going to cover today is the methods of organization and dialogue between business and government. Thank you very much. I've been listening to the panelists, and to the best of my understanding, the role of law, the question that we're discussing now, the role of law is hard to be overestimated. And the Agency of Strategic Initiatives that I'm representing is often confronted with the necessity of improving the law, the regulatory acts, and we understand very well that the legal basis and the law enforcement practice, like the example with the police officer living in that building, all that depends very much on the efficiency of the economy and the investment climate. Mr. Tischendorf has mentioned the rating of the World Bank and Russia's place, which is 120 among 183 positions. It's a pity that Mr. Hassan Hissel left, and we could probably discuss about the very methodology of creating this rating. You can call him, right? But anyway, while Russia is in this 120th place, the President Putin has set a very difficult task of putting Russia in the top 20 within very constrained time limits.
And we can understand how complicated the task is, because let's not forget that other countries, our competitors in this rating, they are also developing and they also perfect their investment climate. But at the last session of the supervisory board, chaired by Mr. Putin, the first 4 roadmaps have been presented within the framework of National Enterprises Initiative. This is the investment climate. In a simple word, in plain words, it's to simplify and to speed up procedures of conducting business in this country. We were based on the World Bank's rating. We have borrowed the main indicators, performance indicators from there, and the main problems, well-known problems: to speed up licensing procedure for construction, tax regulation, perfection, access of Russian companies, medium size, access, support of export by medium-sized Russian companies to the world market, access to energy infrastructure. These are the barriers which prevent both Russian entrepreneurs to conduct their business and, of course, to prevent investors who want to deal with Russia to come here to this country. But what is important to say that this work that has been just recently organized, this activity is organized in a different mode from what it used to be. Entrepreneurs have joined the work group, and they head the task force. So those very people who deal with these problems on a daily basis. Dmitry Ivanovich mentioned that there are problems with the public discussion. This task force have been created online, and we tried to use a mechanism, outsourcing mechanism, when several thousand people are attracted to the solution of a given task. So for each of the roadmaps, we've got a number of proposals, and we were able to outline the roadmap. And I'd like to add that many business people have joined the work, and different business structures and new entrepreneurial organizations that have been organized, Leaders Club. And it is important not only to implement the roadmaps, but it's important to monitor the implementation of these initiatives. Are we moving along the rating, or are we staying in the same place? What is important? I'll bring a few examples. Let's take construction. In this rating, we are in 178th place. There are 51 procedures required to obtain building permit, to obtain construction permit. And average time is 184 days for obtaining construction permit. So by 2020, we have to cut the number of procedures to 7, time limits to 50 days, and the cost has to decrease. Our costs of construction permit are twice as much as the world average. Access to energy infrastructure. Average 2-storied warehouse, 140 kilowatts. In order to get access to energy line, this warehouse has to pay 6 million rubles. So we have to cut it by factor of 80 or 90 by 2020. In order to achieve these goals, it is very important to make amendments to the legislation. And we have discussed this roadmap with the first Deputy Prime Minister, Mr. Shuvalov. And he said that in October or November these initiatives will be submitted to the State Duma, and we do count on changes, on corresponding changes of legislation. Well, when the legislator has omitted about cooperative, now they will probably not omit the changes we have discussed. Thank you for your attention, and I would like to thank Mr. Yevtukhov, my moderator, for inviting me to this round table. Thank you. Well, it's quite clear, as someone who has access to insider's information, he knew that, well, he'll be asked about competitors, so he wanted, he wanted to avoid this discussion and took the earliest plane. But we'll ask him about the competitors. Thank you. And now we move to the second part of our roundtable. I hope live discussion, so please ask your questions to any of the roundtable participants or state your own point of view on the issues discussed. While you talk, while you think about the questions, I'd like just to make two remarks on your presentation. Public discussion of drafts, of legislation draft, they have been practiced before, it's clear. I didn't want to reprimand anyone. I'm talking about the general approach. Sometimes there is public discussion, something is accepted and something not. So the legislator has decided, but this margin of appreciation has also to have certain limits, because the key issue for the business is not the fact that barriers are removed and liberalization takes place, but the certainty is and transparency of authorities' action. And the second remark, and I will think that you will agree with me, that the task set by the President, we definitely welcome it. It's a good thing. However, I believe that at the level of federal ministries and experts, everything is fine. We have great experts, high-level experts, but I would like it to go all the way down through the entire bureaucratic machine. And in order to resolve Putin's problem, I call it each police officer, each prosecutor, each investigator has to know about this task, because to remove barriers is one thing, but you have to maintain it in order for the business to be developed. It should not become prone to attacks on the part of competitor abusing law enforcement in order to remove the competition or to eliminate the competition through using police enforcement. Therefore, I would like to suggest that each policeman has to wake up in the morning and say it as a prayer. I have to implement Putin's tasks today. Or wake him up any time of day or night and ask him, what task? What task has been set by Mr. Putin? And he should say, yes, I know that this is the task for Russia. I agree with you. Who will wake up the policeman? How would you technically implement it? Do you have any ideas? And if you have them, I'd like to discuss. Well, we can discuss it separately. It's not so simple. We have ministers who have to do it, and they have to explain the mission to their staff. They should just fulfill their duties. I have to understand what are those duties, and then we'll resolve the task. And we'll know their name, we'll learn their names soon. Colleagues, pass the microphone, please. I have a question to the judge. Professor Galenskaya, St. Petersburg University Law Department. This for the protocol. We know you. As the graduates of the department, we know you. My question is, we have to remove the barriers. Law and economics, law influences the economics, economics influences the law. It's all good. Could you please tell up to what limit can we remove those barriers, and where state regulation should be rigid? I just wanted to ask you, what is your attitude to prudential regulation of bank law? Because there is no more liberalization. We may not think of a more liberal law, but what is the result? So what's your opinion? Well, it's a rhetoric question.
Well, actually, when the banks are being bankrupted, I often notice that the central bank is the last organization to know about this problem. When we get dozens of complaints, then the central bank wakes up and imposes a certain limitation. But believe me, there are many very good professionals there who are thinking and who are trying to make the oversight more efficient. As for the limits, thank you for this question. I wanted to talk about that. I didn't have enough time. Of course, when we define the goals, one of the goals is the protection of these important public interests, like the creditors' interests. So liberalization should be very cautious, so as not to lay bare the tools that protect the most important public interests, which have to be protected by the law. And I wanted to stress one very important thing. Law has to be minimalistic in this sense, not as in laconic, but from the point of view of minimal limitations. Because we have very many limitations and things that forbid one or something or other, and then we start thinking, what exactly are we forbidding? So this is the art of regulation, with the aim of creating the balance between efficiency and liberalization. Thank you. Thank you. We all know you, dear Lyudmila, as one of the teachers of our leaders of the country. So we would, any participant here would like to ask you, what do you think? I think that because of your instruction, we started to be experts in this. Maybe you would like to give us your opinion, a private opinion. Can I also comment on the example of the banking law? When we created this working group, there were businessmen and officials responsible for the for construction who have been working on this problem since 2010. So the businessmen suggested many bold solutions, such as the implementing of such a methodology that you just have to report the construction procedures, and the officials are quite wary about anything new. You have to strike a balance, even if there are 30 or 20% of what has been conceived will be implemented, this will be a huge step forward. And then, step by step, it will move forward. We covered the 20%, then we reviewed, businessmen and officials together, and then move on. Thank you. Thank you. Our foreign colleagues will think that we have two problems: construction and police officials living in good houses. And how are they in the way of regular people? Any other questions? Well, you know, you were quite correct, because the business doesn't need anything else. The main thing is more freedom, not to be regulated, and in that case, inspiration arrives. In other cases, it doesn't. I think it's very important. It's not a joke. Dear colleagues, I think we have to wrap it up, and on your behalf I would like to thank our speakers, and I'll just say two short things.
With my colleague, if I understood him correctly, I mean, I think the esteemed professor raised a very crucial point, which is that the obsession with deregulation that came out of this neoliberal model that I talked about earlier has taken us into a financial crisis. I mean, a banking crisis where we deregulated inappropriately. I mean, this is obviously my personal opinion, but I think it is a good lesson to learn that, yes, it's very important to free business up from administrative hurdles and from over-regulation, but there are certain limits on that, and we need to make sure that the state is still involved in guiding the economy in a direction that is productive. So I do think that it is clearly very important. All these initiatives that you've been talking about, I think, sound fantastic and are the sorts of things that foreign investors are concerned about, are over too many layers of regulation, too many layers of administrative hurdles. But from a more global perspective, in terms of regulating the economy, I think in some cases we went too far. So. And I'm sorry to have interjected at the end.
Thank you very much for sharing your thoughts. It's very important for us. Dear colleagues, since there are no more questions, there is. Thank you. I just wanted to answer to Mr. Dadov. As a representative of the police enforcement, I don't disagree with the President's tasks, but I think that we have very good way in legislation for limiting the police functions regarding finding various business crimes and so on. And a number of laws were passed to put the police activity within a limited sphere, not interfering with business activities. Because I think the policeman should be waking up with the thought, how can I help business? And limiting bad competition, bad businesses, because the essence of business, the essence of investors is making the rules clear, but also within the law. How can we play, whom we should play with, and have the maximum benefit from it? Thank you. Any other questions? Any questions or remarks? No, thank you. Then just a couple of words. As a moderator, I tried not to abuse my rights, but I just wanted to stress two things as summing up not just this panel but the forum in general. Mr. Medvedev, the Prime Minister, said a very important thing yesterday. The main task of the law, something that was said 200 years ago, is that the main goal of legislation is to create public good, taking into account as many private interests as possible. Now we live in global economy, transnational economy. The investments are, and the law is probably lagging behind that. It has to acquire certain transnational, certain global features to be in step with the development of the global economic community. And summing up the forum, there will be another session devoted to the changes in the civil code of the Russian Federation. But the important thing I want to say is, legal people of the world, unite. Thank you.